Good morning, everyone. Thank you for coming today. I'm going to ask, let's see, Representative Levesque. Can you lead us in the Pledge of Allegiance, please?
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Can we take a moment for silent prayer for those who need it? Thank you. This morning we will attend to the House schedule, public hearings, and we're going to begin with Senate Bill 412. And I am going to call on Representative Rice, who is going to introduce the bill for Senator Victoria Sullivan. Representative Rice.
Thank you. Good morning, Madam Chair and honorable members of the committee. For the record, I am Representative Kim Rice, representing the communities of Hudson and Litchfield in the 38th Hillsborough District. The prime sponsor, Senator Victoria Sullivan, introduced SB 412 at the request of the Department of Health and Human Services. SB 412 seeks to amend the definition of conditional release in RSA 169-B:2, VIII, and RSA 169-D2, D:2, to clarify that as long as a violation is filed within the period of conditional release, the court retains jurisdiction to hear the matter and modify the conditions accordingly. Attorney Susan Larrabee from the department is here to speak on SB 412, walk you through the proposed legislation, and take any questions from the committee. Thank you for your consideration.
Thank you, Representative. Any questions for the representative? Seeing none, thank you very much. Next, I will call Attorney Susan Larrabee and Marie Noonan from DHHS. And they support the bill as well. Good morning.
Good morning, Chairwoman DeSimone and members of the House and Children and Family Law Committee. For the record, my name is Susan Larrabee, and I am General Counsel for DCYF and Legislative Liaison.
Good morning. My name is Marie Noonan. I'm the DCYF Director.
Thank you, Representative Rice, for introducing the bill, and I think I'll begin with maybe a little bit of background. Both the delinquency statute of RSA 169B and the Child in Need of Services statute, 169B. We typically call that CHINS as an acronym. The CHINS and the delinquency statute have very similar purpose statements outlined in Section 1 of both of those statutes. And basically, the purpose of both the CHINS and delinquency statute is to provide fair and effective court proceedings, to provide services and resources to a child whose need to meet the child's needs while promoting the use of personal responsibility, accountability, and appreciation that actions have consequences. Again, delinquency is for a minor who has committed a misdemeanor or felony if they were an adult, and a child in need of services is one who has committed various violations and or various other aspects of the CHINS statute, such as truancy, habitual runaway, and what we call 2D, someone with very high needs who is engaging in very dangerous behavior. In both of those statutes, the court may place a juvenile on conditional release. It is a term of probation. While they are monitored, supervised by a juvenile probation parole officer. Again, we typically call those JPPOs. Again, we love acronyms in DHHS. During that time of probation, they are receiving supervision, they're receiving services, and they're receiving the intervention needs that they have in order to rehabilitate themselves and, of course, to have accountability and services that they need to become law-abiding citizens and healthy citizens, more importantly. Those conditions of release require the youth to abide by 5 major subsections. They are to remain arrest-free and obey all laws. They are to follow all orders of the court, and they are to submit to reasonable searches of themselves and their property. They're not to possess any weapon. And then 5th, they have an individualized, tailored plan that they work on with their probation officer, with their JPPO. Again, various interventions and services for that specific youth to meet their needs. The definition of conditional release also includes subsection D, that the juvenile return to court for a violation of conditions of release and change of disposition at any time during the term of conditional release in which the probation officer files a violation of conditions of release if they feel that minor has violated those conditions. However, there has been differing opinions among the family court judges in which during that time of conditions of release, whether it be a 6-month period or a 12-month period or a 9-month period of probation, they file the motion for violation of conditional release to bring the youth before the court to address their violation. However, there's times when that term of probation ends before the court has scheduled the violation. One court recently held that although the violation motion was filed during the pendency of that conditions of release, there was not time to hold the hearing or issue an order. Therefore, they felt they did not have authority to hear it, so they closed that as being holding that they lack authority to dispose of the motion. This added language in Senate Bill 412 would give the court clear authority to retain jurisdiction and hear the violation, as long as the violation was filed during the time of the conditions of release before the expiration. And we feel that this is consistent with that first purpose that we talked about at the very beginning of my testimony here, that the statute is for rehabilitation and accountability, and to hold otherwise we feel would be nonsensical. And I'm happy to take any questions. Sorry for being long-winded this early in the morning.
That's okay. Thank you. Marie, do you have anything to add at this time?
I don't, thank you.
Would you both be agreeable to take questions at this time?
Of course.
Thank you. Any questions? Brain cramp Representative Raymond.
Thank you, Madam Chairman. Thank you for taking my question. So in those circumstances where, because of court delays or whatever reason, the hearing happens after the end of the original probationary period. Now with this, they can still have the hearing, which I think is good. Does this also authorize the judge to extend the probationary period or have some other consequence? Like, does it reset a clock? Like, how does that work?
It doesn't necessarily reset a clock, but yes, it allows the judge to still have jurisdiction to modify that original disposition. And that's already in statute, saying it. To return to the court for violations of conditions of release and change of disposition at any time during the term of conditional release.
Okay. Follow-up question, please. Thank you. So is there a limit to how many times they can do it, or an age limit? Like if the child is, 16 or 17, could they continue on until they turn 18, assuming that they're really struggling to follow their conditions?
Yes and no. They can retain jurisdiction up until 18 for some cases. Some cases by statute have to close within 2 years of disposition. For those that are not violent, they're called violent serious offenses, and they're delineated in statute. For all others, the case must close within 2 years of adjudication.
Thank you.
Seeing no further questions, I thank you very much today for coming today and giving us that extra information. I appreciate you.
Thank you.
Seeing no other pink cards, I have to hold the hearing time open for a little bit, but I think we can ask Representative Rice to come back to the table. I'll close the hearing. And I'm going to open an exec session for House Bill 412. Senate Bill, House 12. Thank you for the correction.
Okay.
Do I hear a motion on Senate Bill 412?
I'll move OTP.
Representative Rice moves OTP. Representative Gregg seconds. We're open for discussion. Any discussion? Representative Raymond.
This seems like common sense. I'm disappointed that it wasn't already in statute.
Agreed by all, I believe. Any other comments? Seeing none, when the clerk is ready, I will ask her to call the roll.
Motion is OTP. Representative Rice,
Yes.
Representative Pearson,
Yes.
Representative Nelson,
Yes.
Representative Love.
Yes.
Representative Corzine, yes. Representative Markel,
Yes.
Representative Petrino,
Yes.
Representative Scher,
Yes.
Representative Levesque,
Yes.
Representative Gregg,
Yes.
Representative Raymond.
Yes.
Representative Georges,
Yes.
and Representative Manos.
Yes.
And Chairman DeSimone, sorry.
Chairman votes yes.
14-0.
I see that it is unanimous. Representative Pearson, do you have a motion?
Well, the only thing that comes to me is this might wonderfully go on consent.
Without objection, this may go on consent. Thank you, Representative Pearson.
I do want to point out the brilliance of Representative Pearson's motion.
I long for the day when you may call me one of your students.
As do I.
So I'm wondering if it happens to have anything to do with gender. Because Representative Georges did not have to crack the whip.
I'm outraged by the chair's.
Excuse me?
I'm outraged by the chair's sexist comment.
I'm sure. I think you actually love it, but that's okay.
No comment.
He's a defense lawyer. What do you expect?
So we're going to take a little bit of a break. If you want to catch up, you can reread the huge Senate Bill 413, probably about 25 times in the next 15 minutes, and taking a break in between. However, just relax a bit. The next hearing will begin at 10:30. Representative Raymond.
Thank you, Madam Chair. I have a question about the big giant pile of research sitting on my desk.
That was mine. I just wanted a recap of everything we've done over the past 10 years.
This is beautiful.
Isn't
That
it?
was all Miss Kristen over there.
Thank you.
She is one of the best, and I don't know of anybody better, but we're very thankful to have
Yes.
her. It is now 10:30. I will open the hearing on, I'm gonna give her a minute. I'll open the hearing on Senate Bill 413 relative to the detention of a minor attaining the age of 18 during the pendency of a delinquency action. And at this time, I will recognize Representative Kim Rice on behalf of Senator Victoria Sullivan. Representative Rice.
Thank you, Madam Chair. Thank you, members of the committee. For the record, I am Representative Kim Rice, representing the communities of Hudson and Litchfield. The prime sponsor, Senator Victoria Sullivan, introduced SB 413 at the request of the New Hampshire Department of Health and Human Services. SB 413 would amend RSA 169-B:14I, Section E, to specify the facility in which alleged delinquent minors may be held in detention pending a hearing, permitting alleged delinquent minors to be housed in a county corrections facility once reaching age 18. Attorney Susan Larrabee from the department is here to speak on SB 413, walk us through the bill, and to take any questions from the committee. Thank you for your consideration.
Any questions for Representative Rice? Thank you. Seeing none, thank you, Representative Rice. I will now call on attorneys Susan Larrabee and Marie Noonan, both from DCYF. I'll just say that taking into consideration, those are the only two pink cards I have. I usually will time people who testify to 3 minutes. I'm going to let that go for today because we do have 30 minutes per bill. So rather than sit around doing nothing, I will allow anybody to be as long-winded as they so choose.
Very dangerous for us lawyers.
And with the exception of the 3 lawyers.
Thank you,
Thank you.
Chairman DeSimone, and thank you, Representative Rice, for introducing the bill. Again, my name is Susan Larrabee, General Counsel and Legislative Liaison for DCYF.
Good morning again, Marie Noonan, Director of DCYF.
As Representative Rice described, this bill amends the delinquency statute of specifically 169B:14, Roman numeral 1E, detention pending adjudication statute, to specify that those charged under the delinquency statute who turns 18 during the pendency of the adjudication may be held at a county correctional facility once reaching the age of 18. The basis for this legislation stems from an identified gap in the law, which was recently litigated up to the Supreme Court. The dispositional statute of 169B:19 specifically states that a minor may be committed to the youth detention center only until the age of 18. However, the detention statute, unlike the committal statute, does not have that specific language. And again, detention is for those minors who are arrested and charged with a misdemeanor or a felony, who have been deemed to be a danger to themselves or others, such that they need to be detained prior to the adjudication. And then the committal is what happens after the adjudication, the sentencing, so to speak, that they are then sentenced to YDC, currently named SYSC here, Sununu Youth Center, until the age of 18. This gap in the law led to a 2024 appeal with the New Hampshire Supreme Court, in re AG 2024, New Hampshire 32. And I do have numerous copies if that would be helpful. May I approach? In that published opinion, the court explained this factual scenario and procedural history of the appeal. A 17-year-old was arrested and petitioned on various charges, including first-degree assault, reckless conduct, falsifying physical evidence. The family court found probable cause that he met the standard for secured detention pending adjudication. That he was an immediate danger to himself or others, that pre-adjudication detention was deemed necessary by the court. The state then commenced what's called a certification proceeding to certify that minor as an adult, in which he would then be deemed an adult and face charges in the adult world for the conduct he committed. It's a two-prong process. In that process, the first prong occurred that the family court found that he was to be certified and the case was transferred to the Superior Court. However, the Superior Court then has to hold a separate hearing to determine that certification process. There is no time limit with that. That makes the adjudication on hold. He is not adjudicated. He remains at SYSC detained on the petitions. In the interim period, that individual, AG, turned 18 years of age, and the circuit judge ordered that he be transferred to the House of Corrections, being that he was now 18 years of age. And his attorney appealed this transfer. The Supreme Court held that 169B14 in its current state does not specifically authorize this transfer due to the gap that I identified earlier. That language was not in the detention statute. It was only in the committal statute. And this added language would now close that gap. The bill would align the detention statute with the committal statute, in which it is deemed that this youth, once they reach the age of 18, is no longer to be held at the youth detention center. As you can see in the last paragraph of the holding, the Supreme Court stated in its closing, of course, if the legislature disagrees with our construction, it is free to amend the statute as it sees fit. And that is why we are before you today, that it is in everyone's best interest for the safety and welfare for those at SYSC that there be a uniform census population there, that jurisdiction over that individual should end at 18 and should not be held at SYSC. And I'm happy to take any questions as well as Director Noonan.
Representative Scher.
Thank you, Madam Chair. So I want to just clear something up in my mind. If a juvenile allegedly commits offense at the age of 17 3/4 and is not certified as an adult for purposes of what the offenses are, when does the juvenile court's jurisdiction, two parts of the question, when does the juvenile court's jurisdiction end, and can the juvenile court sentence that 17 3/4-year-old to a sentence that runs past the age of 18?
It's a very complicated part of the statute in the disposition.
Your mic.
Oh, sorry. It's a very complicated section of the dispositional statute, and I'll read it. Currently, what was unique about this situation and why it's the certification process that is the problem is that there are tight time frames and strict time frames for a youth who is charged in a delinquency matter and being held at SYSC. If they are being held at SYSC, they are to have their adjudication within 30 days of them being detained at SYSC. And then following that adjudication, they are to have a committal hearing, a dispositional hearing, within 21 days of that adjudication. So they would only be held about 51 days at max before they have a dispositional hearing.
Follow up.
So they have their dispositional hearing. It's still slightly before they turn 18. what is the length of any quote-unquote sentence that the juvenile court can impose on that not quite 18-year-old? Another way to put it is, does the courts, can they only sentence him to what's left in his minority, or can they give him a sentence that requires that he be held past the age of 18?
He cannot be held at SYSC past the age of 18. Literally at their 18th birthday, they are released from SYSC based on the statute. There is a portion of the statute under extended jurisdiction where, based on certain factors, court can extend jurisdiction over that individual, but that individual will not remain at SYSC past the age of 18.
One more follow-up.
One more follow-up, sure.
So, am I correct in understanding that this only this bill, SB 413, only applies to the circumstance of a juvenile who is in the process of being certified as an adult?
Correct, because of the tight time frames of those who remain at SYSC and are being adjudicated under the delinquency statute, yes.
Thank you.
Representative Corson.
Thank you, Madam Chair, and thank you for being here. I just have to ask this just to make sure. We're talking strictly about a placement bill. We're not talking about upgrading charges as an adult or anything like that.
Correct.
Okay, thank you.
Correct.
Representative Raymond.
Thank you, Madam Chairman. Thank you for taking my question. So what happens when SYSC closes this year? Where do these kids go in these circumstances? Like, will they go to Hampstead to the treatment center, or will they go someplace else?
So yes, I mean, SYSC is the YDC, the Youth Detention Center, will have a new camp on the campus of Hampstead Hospital, but it will be a new secured detention. And there will be no time where there is not, the new one open and the other one closed.
Thank you.
So upon the opening of the Hampstead facility, the children will stay at the Sununu Center. They will then move to the Hampstead facility, and then the Manchester facility will close. So they will not be displaced.
Thank you.
Representative Pearson.
Thank you, Madam Chairman, and thank you for taking my question. I'm trying to pull two or three different things together, and apologies if they all fall flat together. Sometimes in this committee, we've heard the concerns and complaints of people who's supposed to be in court for their hearing and they get bumped. And would it be the case that if somebody's has to be heard within 30 or 20 days, that gets plugged in, and that could be a reason why somebody unfortunately gets bumped?
The time frames in basically everything DCYF does in terms of delinquency, chins, and child protection cases, they are in statute, so there's strict time frames. I do believe that the family court prioritizes those cases in which there are the strict time frames that we have to meet, both statutorily here as well as federally.
Follow up?
Follow up.
So if those must be heard, and we have a couple of them, something's going to be pushed back. Is that correct?
I can't speak to the family court's framework of how they decide and triage what cases they give court time to.
Okay, thank you.
Representative Scher.
My experience has been that when it's a juvenile case, I'm answering, isn't it, let me ask the question then. Isn't it the case that most juvenile courts, circuit courts, prioritize juvenile cases because of the deadline?
Yes, juvenile cases and child protection as well that have strict time frame for the best interest of the child.
Thank you.
Do I see any other hands up for any further questions? Seeing none, in that case, I will close the hearing on Senate Bill 413. And I will open the exec session on Senate Bill 413. And do I hear a motion, Representative Corzine?
Thank you, Madam Chair. I move ought to pass.
Representative Corzine moves ought to pass. Representative Rice is seconding that. Any discussion? Seeing none, oh, go ahead.
I was just going to say, I think that this would bring us into line with what the Supreme Court just ruled.
Good job. Seeing no, Representative Scher.
I would, in the ideal world, I would prefer that this make it more clear that this only involves a juvenile undergoing the certification process. But we've had clear testimony, and so the legislative history reflects what it only applies to. So I'm fine with it.
Thank you. Any further discussion, questions? Then in that case, I will ask the clerk to call the roll as soon as she's ready.
Representative Rice,
Yes.
Representative Pearson,
Yes.
Representative Nelson,
Yes.
Representative Love.
Yes.
Clerk votes yes. Representative Markel,
Yes.
Representative Pedrino,
Yes.
Representative Scher,
Yes.
Representative Levesque,
Yes.
Representative Gregg,
Yes.
Representative Raymond, Representative Georges,
Yes.
Representative Manos,
Yes.
and Chairman DeSimone.
Yes.
14-0.
Representative Pearson, do I hear a motion?
Well, yes, given our troubled times and the variety of motions that could be made, and reading the room as I just did, I would suggest this goes on consent.
Do I see any objection to consent? Seeing none, consent it is. Thank you, Representative Pearson. Thank you, Children and Family Law Committee. We have a few minutes to relax a bit and get ready for the next bill, House Bill 515.
My husband said I write like a first grader.
My husband has
Mhm.
well, I'm a lefty, and
See, that does play a difference.
when I have to go to remedial handwriting classes.
Oh. That's sad.
My mother was a lefty, and when she was in school, she was public school.
You're so good.
I've heard of that. What is that? Get out.
believe that I have, you know, but.
Okay, it is a little after 11, and I will open the hearing on House Bill 550, Senate Bill 515 FN. And with that, I do not see Senator Long in the room. Representative Petrino did tell me yesterday, I told you I'm confused. Representative Petrino told me that he will be introducing the bill on behalf of Senator Long. Representative Petrino, you are recognized.
Thank you very much, Madam Chairwoman and members of the committee. For the record, I'm Peter Petrino, and I represent the town of Milford, and I'm here on behalf of Senator Pat Long, and he's asked me to read this opening statement. Good morning, Chairman DeSimone and honorable members of the House Children and Family Law Committee. For the record, I'm Senator Pat Long, representing Senate District 20, and I am the prime sponsor of Senate Bill 515, being made at the request of the New Hampshire Department of Health and Human Services. First, sections 1 through 3 of Senate Bill 515 would make minor adjustments to various parts of RSA 169B, delinquency, RSA 169C, child protection, and RSA 169D, children in need of services, to clarify and align these state statutes with federal requirements. These federal standards include the Qualified Residential Treatment Program, QRTP, Title 4E, Comprehensive Assessment for Treatment, CAT, conducted within 30 days of the placement at a QRTP, and the judicial determinations that must be made within 60 days of a child's QRTP placement. These requirements are outlined in the Federal Family First Prevention Services Act. Essentially, the proposed legislation updates language to clarify the existing responsibilities of both the department and the court. Second, Section 4 of Senate Bill 515 would amend RSA 169C10, Roman numeral 2, to keep current law in subparagraph Roman numeral 2E2, which is scheduled to sunset on August 1st, 2026. It allows the court to proceed with litigation in any action in which, despite diligent efforts to secure counsel, an attorney is not available for appointment. Litigation may proceed until an attorney becomes available. This legislation is crucial to ensure the permanency and best interest of children. Finally, Section 5 offers a one-year sunset clause for the previously highlighted Section 4, and Attorney Susan Larrabee from the department is here to discuss Senate Bill 515, walk you through the proposed legislation, and answer any questions from the committee. Thank you for your consideration of the bill. This is from Senator Pat Long. Thank you very much.
Thank you, Representative Petrino, on behalf of Senator Long. Does anybody have any questions for Representative Petrino? Seeing none, thank you very much for introducing the bill. The next card I have is from the dynamic duo of Attorney Susan Larrabee and Marie Noonan. Come on out. Thank you for coming again and helping us out with this bill.
Thank you, Chairman DeSimone, and thank you, members of the Child and Family Law Committee. Again, my name is Susan Larrabee. I'm General Counsel and Legislative Liaison for DCYF.
Good morning again, Marie Noonan, DCYF Director.
As mentioned in the introduction, this bill has two parts. The first part seeks to amend the identical language in all three statutes of 169B, the delinquency statute, 169C of the Child Protection Act, and 169D of the CHIN statute, because the current law, as stated in state statute, does not accurately state the federal law language of the Family First Services Prevention Act that requires certain requirements to be met in order for the state to receive Title 4E funding for the placement of a child at a qualified residential treatment program, otherwise termed a QRTP. Under the Family First Act, there's two major requirements that is addressed in federal statute. Within 30 days of a child's placement at a qualified residential treatment placement, a trained professional not affiliated with the state agency, which is termed a QI, a qualified individual in federal law, must complete an assessment to determine if the QRTP is the most appropriate, least restrictive setting for the child. In our state, we contract with Maximus, who perform what's known as a CAT, a Comprehensive Assessment for Treatment, meeting that section of the statute. And then secondly, within 60 days of placement, a family court must approve or disapprove the QRTP placement after review of the CAT assessment and other evidence. As you can see before you in the bill, these state statutes that were passed in 2021 to implement the Family First Service Prevention Act misstates the federal law, requiring in the way it's written that the court order the CAT. We have changed that to make the state statute comply and be identical to the federal statute, in which the department has a CAT done within the time frames in the statute, and then the court then approves or disapproves the placement at the QRTP. Again, it's just aligning state statute with the federal statute. The second part of the bill is contained on page 2 of the statute, beginning on line 3. To give some procedural background and context on this section, in 2024, the legislature passed Senate Bill 463, which made significant revisions to RSA 169C10, in which in an open child protection case, in addition to being appointed a guardian ad litem to represent the child's best interest, an attorney may be appointed to represent the express interests in any 169C case. So they would represent the child in addition to having a GAL represent them. In all 169C cases, the child may request an attorney be appointed. That's known as the discretionary appointment of counsel contained in 169C10. And then that enacted legislation further provided for the mandatory appointment of counsel for any child placed in a residential treatment program, or when a residential treatment program is being contemplated by the department. The court shall appoint an attorney to represent the express interests of the child. The original bill had an effective date of July 1st, 2025. Within that legislation, it was included a phased-in implementation process, and that was contained in 169C10E1. I think maybe I do have copies of the way the statute is, and that might be helpful because it gets a little confusing as to what sunsets and what doesn't sunset. If I could approach. So as currently in statute, until August 1st of 2026, there is the section in 169C10 E2. After the phased-in approach of those children being appointed counsel that are in a residential treatment program based on age and time of and where they are located in their placement. It says, notwithstanding this paragraph, In any action in which, despite diligent efforts to secure counsel, an attorney is not available for appointment, litigation may proceed until an attorney becomes available. In such cases, the court shall, where possible, prioritize consideration of legal issues that do not affect the child's express interest until an attorney becomes available. Again, a very narrow carve out of proceeding with a case until an attorney can be found and appointed to represent that child. So the statute as a whole effective date was originally 7/1/2025. However, last summer, the trailer budget bill, House Bill 2, delayed the implementation of Senate Bill 463 from 7/1/25 to 1/1/2026. However, House Bill 2 did not change any of the dates and timeframes contained within this bill during that phased-in process. It has a lot of timeframes. What we have done and what we continue to do is work collaboratively with all stakeholders involved in this through the model court to make sure that the family courts in the state have assigned those already in an RTP at the time of the effective date as of 1/1/26. That was approximately 150 youth. Assign them and appoint them an attorney, having that attorney come up to speed on the case. And now, as of 1/1/26, the DCYF must notify the court when we are contemplating determining if the child's needs are such that they require an RTP. We notify the court so the court can then appoint counsel to represent those children as well. And everyone has done a great job staying on top of that, being very cognizant of the fact that there is an attorney shortage in this country, in this state. I know Lisa Wolford is here in the audience. I'm sure she plans on testifying. Her, as well as others, have trained and brought on as many attorneys as they can to become eligible to represent these children in RTP who are eligible for mandatory appointment of counsel, as well as those who have a discretionary right to request an attorney. There's always a concern that there will never be enough attorneys to represent children. This is a very, very narrow carve out. It will sunset now on 8/1/26 as written in the original bill. We are asking for it to sunset now a year later. We talked earlier, there are so many strict mandatory timeframes for moving a case forward when a child has been removed from the home. It is in the best interest of the child to have timely permanency. That is drafted within the federal legislation of child protection cases, as well as the state statutes on child protection cases. For instance, we have protections in which an adjudicatory hearing shall be held, written findings issued within 60 days of the date of the petition was filed. The dispositional hearing shall be held within 30 days of the finding of abuse and neglect. An initial 3-month review hearing shall be held within 3 months of the dispositional hearing, all leading up to a permanency hearing required federally to be held at the 12-month point of that child being removed from the home. Because again, it is in the best interest of the child to have a timely permanency. And we do not want cases delayed because an attorney to represent the child cannot be appointed. This would, again, be a very narrow carve out in which the case can proceed, again, emphasizing dealing with and having the abuse and neglect case go forward, and then appoint an attorney for the child as soon as possible without delaying timely permanency. And I'm happy to take any questions.
Representative Rice.
Thank you, Madam Chair. Thank you for taking my question. Are there any kiddos right now that don't have an attorney? Are you finding you have plenty? What is the story there?
I can't answer that. I don't know if there's anyone here from the court. Oh, yes, somebody is here from the court who would be better able to answer that specific question.
Thank you.
Representative Pearson.
Thank you, Madam Chairman, and thank you for taking my question. If I recall, when this came up the last time, the difference between a guardian ad litem is the guardian ad litem represents the best interests of the child as the guardian perceives it, whereas a lawyer would represent the best interests of the child as the child perceives it. Is that correct?
Correct. A guardian ad litem by statute is appointed to represent the best interest of the child, whereas an attorney, according to the statute, is to represent the expressed interest of the child.
Thank you.
Representative Corzine.
Thank you, Madam Chair. Thank you again for being here. I am really hesitant about not having the child's voice represented. That scares me. How is there any way around that? I mean, the child should be representing, this is his life, this is his, we should be watching out for his best interest, not everyone else except him.
Absolutely. I think the court is doing a great job appointing attorneys immediately. And again, this is a very, very narrow carve out. Again, litigation may proceed until an attorney becomes available. In such cases, the court shall, where possible, prioritize consideration of legal issues that do not affect the child's express interest until an attorney becomes available. Again, focusing on the abuse and neglect case going forward, whether it be the adjudication of a parent or caregiver of the abuse or neglect, the disposition hearing, the first review hearing to establish where we are at with mom and dad or the parent or caregiver who has a finding against them in terms of their movement towards permanency, while diligent efforts to immediately appoint an attorney to represent that child's express interests.
Representative Raymond.
Thank you, Madam Chair. Thank you for taking my question. So I'm still confused about the effective dates, and I apologize.
Yeah.
I have the handout. I have this. I know that there's an amendment coming. So if we, putting aside all of the other requirements that we have to do to comply with the federal law, just talking about the effective dates. If we don't change the effective dates, what happens this summer? Do kids get attorneys or not get attorneys?
The only change is that as of August 1st, 2026,
Yep.
the effective date, the repeal of that small carve out is repealed. It
Okay.
sunsets naturally. What happened was when HB2 delayed the start of attorneys for children to 1/1/26, it didn't change any of those timeframes within the statute, including the 6 month or the year to get on and have every kid appoint an attorney and get up to speed and maintain that phased in. So the phased in does not change. The only thing that changes is that the sunsetting of the carve out to proceed with a case is now extended for a year.
Follow up? And do you need the year to do the training and the recruiting? Because I thought that was kind of happening now. So I'm confused about that.
I think it's going to be happening continuously.
Okay.
Because there's a limited amount of attorneys in the state. There's a limited amount of attorneys who have agreed to represent parents. Now there's another pool of attorneys who have agreed to represent children in these cases. And they're constantly recruiting and training attorneys.
Okay. One last follow up. But the monies to do the training and to pay for some of these attorneys have already been put aside as part of HB2, correct?
I don't believe there was any money ever associated with HB2 or
With-
House
with this
Senate Bill
part.
463.
Okay. Thank you. I know there was no fiscal note on this one either, but okay, thank you. Right, the fiscal note said that there was no fiscal impact. So it didn't have a dollar sign on it.
And that would be the Judicial Council's budget item for paying court-appointed attorneys.
Representative Georges.
Thank you, Madam Chair. Thank you for taking my question. I'm a little bit confused. If there is no lawyer, there is no help for the child, what is going to be the consequence for that child?
So if the child does not have an attorney to represent their express interests, and if we do not allow the additional year to ramp up and train to ensure that all kids have attorneys, the potential consequences for kids is that their permanency could be delayed. The hearings that would move forward in the identified timeframes that Attorney Larrabee discussed would potentially cease if we could not move forward with the case, so the child could linger without permanency for a longer period of time. There would also the GAL being appointed. I know there's a reason to have an attorney for the express interest, but while a case could continue with certain carve-outs that Attorney Larrabee described around maybe not litigating certain aspects that would impact a child's express interest, if the case were to move forward, they would still have the guardian ad litem representing their express interests. I'm sorry, their best interests.
Follow up? Thank you, Madam Chair. If it's delayed, for how long? And I don't know, because if it's delayed, how long the child gonna be, and what happened for that child is gonna be 3 years or 4 years just waiting for the lawyer or the attorney?
Thank you for your question. So in this bill, the recommendation is that we allow an additional year to be able to ensure that there are enough attorneys appointed for children. So no situation would be delayed, for longer than 1 year. And what this bill contemplates, again, as Attorney Larrabee was describing, but I know it is confusing. It's very confusing. Is that the legislature intended to allow a ramp-up period for training and ensuring the court could appoint attorneys. But with House Bill 2, the ramp-up was eliminated, and there was a date certain for this to start for everyone. So we're trying to go back, if you will, to the period of time, the staggered approach that was initially identified for the judicial branch to have adequate numbers of attorneys to represent kids.
Thank you. Representative Gregg.
Thank you, Madam Chair, and thank you for being here. It's nice to see you all back in the room again. So this was a conversation. We had a House bill at the same time the Senate bill was coming up with this, because we all, in a very bipartisan way, thought that children needed representation. So that's not the problem. The issue was, do we have enough attorneys? Is there this buildup and stuff? So wouldn't you say that, having this kind of like kick out is to make sure that we had it? Because there was discussion at the time, well, we don't know if we have enough attorneys, so we can't pass it. This particular committee said, absolutely not. We're not going to wait. We're going to pass this and, force the issue because we think it's so important. So is that not what this kick out is for? It's to make sure that we do not have delays, that we are getting it right so that everybody can have representation.
Absolutely, and not have the unintended opposite result. Instead of having quicker timely permanency, we're delaying timely permanency. Again, the best interest of the child is always our number one concern. We do not want to delay that process while they're trying to appoint an attorney for a child.
Representative Scher.
Just to be clear, the guardian ad litem need not be an attorney, right?
Correct.
Do you have any sense of how many of the guardian ad litems that are being used by courts are attorneys?
I know by statute they are they always go to CASA first. And I know CASA is here in the audience, and they are able to answer how many are attorneys from from CASA, and then they go to the private GALs.
Thank you.
And again, there's very robust protocols of children and youth in court. Prior to any changes to 169C10, there's always the right and the promoting that child come to court and express their interest to the judge, and that's in protocols for children and youth in court.
Representative Manos.
Thank you, Madam Chair, and thank you for taking my question. The child's right to counsel is rooted in the Constitution, is it not? Because the child's liberty interest is at stake. Is that not correct?
I don't know really what you mean by liberty, in terms of when they have a need that requires them to go to a residential treatment placement. Kids in a delinquency case, yes, have a right to an attorney by the Constitution, and they have always had a right to an attorney.
Is that not also the case in this situation because placement implicates liberty interests?
To answer your question, not that I'm aware, and if anybody is more well-versed in the Constitution than I and can point out to me where it would point to that, I'd be happy to take that information. But as far as I know, it is not constitutionally required in this instance. Representative Scher.
In that vein, if I could help the discussion, my understanding is there is not currently a constitutional basis for right to counsel at that level. The right to counsel over the years has become an important statutory one, but it isn't. Though one might sometimes the right to counsel comes from the due process clause of the Constitution, but the right to counsel in delinquency proceedings and criminal proceedings is a function of them being criminal proceedings.
Thank you. Representative Raymond.
Thank you, Madam Chairman. If I can just piggyback off of Representative Scher, the distinction here is that we're talking about victims of child abuse and neglect, and the placement is to ensure their safety, not to protect the community from them. So they're not being accused of anything. They're being placed because of they need to be in a safe place and in a residential placement because of their own unique needs that can't be met otherwise.
Right. Thank you. Thank you. Okay. Seeing no other hands, thank you very much for your expertise. And next, I will call Karen Rosenberg.
Good morning, Chairwoman DeSimone, Karen Rosenberg. I'm the Policy Director for the Disability Rights Center. And I would like to explain kind of how we got to where we are on SB 515 as amended, and talk to you a bit about what I understand is an amendment that might come before you. So
I'm sorry to interrupt you, but
That's okay.
I'm going to have to quickly recess this hearing on 5:15, and we will go into recess. Stay right where you are,
I won't
please.
move.
I'm going to open the hearing on House Bill 608. I'm going to go into recess on House Bill 608, and I'm going to reopen the hearing on Senate Bill 515. And Madam Rosenberg, thank you. Continue.
Thank you. That was quick. So just like little small history lesson. In 2024, you all in the Senate passed SB 463, which established a right to counsel for certain children who are in the child protection services system. And these are children who are either in institutional placements or congregate care or at risk of those placements. And in doing so, there was a recognition that children who are in these placements or in the child protection system need to be able to have their own voices heard by the court. And while it is, it is important that there be a CASA or a guardian ad litem also participating to give their view of what the child's best interest was, that what was missing was the voice of children who are most directly impacted in these cases. Because in addition to being in a household where they were allegedly abused or neglected, they're also looking at being removed from their communities and placed in unfamiliar homes or settings. And what was most concerning were children who were placed in institutional congregate settings. So this bill passed with resounding support. It was bipartisan. Then go to 2025. There was an effort to roll back this bill and postpone the effective date of the right to counsel that it created for 2 whole years. But as it turned out, this was in the budget rider, as Susan Larrabee explained to you. It was an HB2. Ultimately, there was pushback on that. And HB2 was amended, and because it was so late in the session, there was a 6-month delay in the implementation of this narrow right to counsel for children. And when this bill was kind of going through the process, there was a lot of discussion about what happens if we can't find counsel? There may not be enough attorneys. We can't have a situation where we have this established right and we can't fulfill it. And so there was a phase-in schedule that was part of the original bill. And there was a small exception carve out for situations in which, despite the child being in a position where they had a right to counsel, the court's diligent effort to appoint counsel were not able to be appointed for some reason. So this was something that was negotiated, and although my office and others felt like these are great cases, people are going to want them, we're going to have attorneys, there were other folks who weren't as optimistic, and so it was a compromise to have a phase-in schedule and an exception that would allow some leeway for cases to continue. Well, as Susan Larrabee accurately pointed out, the delay of the implementation of this right did not include a delay in this carve-out. And so, although, like I said, ever the optimist, we felt like this was going to go really well, there were still folks who felt like, well, maybe it won't go that well. And so SB 515 was introduced, and the language of SB 515 as it was introduced would have continued this exception to the right to counsel for children forever. So that was what the effect of that bill would have done. And I just want to remind you that in no other statute that establishes a right to counsel do we have an exception that says, okay, well, you're entitled to counsel for your termination of parental rights, but sometimes you're not going to get it. Or you're entitled to counsel if you're in the delinquency system, but in some narrow circumstances, you're not going to get it. We don't have any of that. But we did recognize that this exception, that had been created, didn't continue for the duration that was projected when the bill originally passed. So some other folks who work on juvenile policy matters came together with the department to try to iron out a compromise. And that compromise is reflected in SB 515 as amended. And what SB 515 as amended does is it actually gives a little bit longer than was originally contemplated by the original bill. But in order to align with filing deadlines for the legislature, we agreed to push out that the carve out even a little bit further. So as amended by the Senate, the department would have, not the department, children could potentially go without counsel for this limited time for this carve out until August 1st of 2027. If this amendment, if this bill is amended by the Senate did not pass and we were back to the original law, the carve out would only exist until August 1st of 2026, this year. So we felt comfortable that, although we didn't love having an exception to the right to children to have counsel in these instances, that, it was something that, we wanted, we all came together and we felt comfortable in general that this would be okay. And the good news is, my understanding, and maybe you'll hear from the courts about this, is that actually this law has only been in effect since January, and it's going really well. And children are being appointed counsel. And the courts have done a really good job at identifying counsel. Counsel have stepped up. There have been training efforts. And so, fingers crossed, this success continues and children will continue to have a voice, and we won't have a need to create a right that has an exception in such an important matter. So I'm happy to take questions.
Representative Raymond.
Thank you, Madam Chairman. Thank you for taking my question. So my question is, and I think I have it from your testimony, on the page 2, line 12, where it says, Roman numeral 2, section 5 of this act shall take effect August 1st, 2027. That ensures that after that date, kids will have an attorney. They don't get the carve out.
Exactly.
Okay. And so if that line is removed, because I think we might have an amendment, does that mean that kids can go without an attorney indefinitely?
Exactly.
Okay.
It would continue the exception to the right to counsel indefinitely, which, like I said, there's no other statute creating a right to counsel that has an exception to that right built in.
Thank you.
Representative Scher.
So I'm going to go back to prehistory when I actually was practicing in district courts and representing juveniles many decades ago. And the attitude then, and there is a question here, the attitude then of some judges before whom I practiced was, you damn lawyers, you get in the way of doing the right thing for juveniles. I heard that a lot. I'm curious, have things changed with judges in these kind of cases that are obligated to appoint counsel, but got a loophole that a large truck might be able to be driven through?
Honestly, I think that Lisa Wolford, who's also here, who will testify, who's actually doing these cases now, would be the better person to answer it, because I'm not doing these cases currently.
Thank you.
Seeing no further questions, thank you very much.
Thank you.
Next, I'll call on Lisa Wolford.
Thank you. Good morning.
Thank you. Good morning.
For the record, my name is Lisa Wolford. I am the executive director of the Children's Law Center of New Hampshire. We are a legal services nonprofit. I am a lawyer. We are a startup nonprofit. We are 3 years old. We have one other lawyer, and we are hiring a third in the next 2 months. If you know anyone, send them our way. I want to touch on a couple of points. I'll just give you a little bit of our experience with the implementation of SB 463. We always believed, and we told the legislature during the course of SB 463's navigation through the legislative process, that attorneys would want to represent children, and that we would train them up and that we would help recruit. And we have done all that. Lawyers do want to help children, and there has not been a problem. I think you'll hear that from Jessica King from the Administrative Office of the Court, and I think you've heard that from others who've testified already this morning. We took 6 cases, 5 in January, 1 recently in 3 different courts, Laconia, Dover, and Manchester. We represent children at the Pine Haven facility in Allenstown, at Webster House in Manchester, at Mount Prospect Academy, in Plymouth, in the Nashua Children's Home, in a placement in Massachusetts, and a placement in Oklahoma. We provided training, free training for lawyers. Lawyers like, well, everybody likes free things, but lawyers like trainings because they have continuing legal education requirements. And so these free trainings provided them with a year's worth of continuing legal education programs credits. We did that in January of last year, anticipating at that point that the right to counsel would go live in July of 2025. We had a follow-up training in September of last year, and we have a training scheduled for May of this year. A quick point on CASAs versus lawyers. Representative Sure, you asked about how many CASAs or guardians ad litem might be lawyers. I don't think it matters because children are a party to the case. CASAs and guardians ad litem are parties to the case. The CASA or guardian ad litem cannot represent the child's legal interests. So one party cannot represent the legal interests of another. I should also stress that these cases are very complex legal proceedings in which children have very, very many rights. And New Hampshire was one of 6 states before the advent of SB 463 that did not provide the right to counsel to victims of abuse and neglect. And that I'll remind this body that the predicate for the right to counsel was the small population or smaller population of children who DCYFN courts sent to institutional placement to congregate care, right? And outcomes for kids in congregate care are not good. And in fact, children, when sent to congregate care, the data suggests, and I have a Casey Family Programs 2-page brief that I'll circulate, suggests that institutional placement, congregate care, in fact, interferes with permanency, right? So the goal was get counsel to represent children in complicated legal proceedings, to amplify the voices of children and provide the legal advocacy necessary to have the child be able to navigate these complicated systems. A quick point about liberty interest. So I disagree that children in 169C abuse and neglect cases don't have a liberty right implicated by their placement in congregate care. I think what is true is that right now in the state of New Hampshire, there is not a constitutional right the New Hampshire Supreme Court has never said there's a constitutional right to counsel for these kids. What is true is that the New Hampshire Supreme Court has never said that these children have a liberty interest. But I will suggest to you that there is a liberty interest, no different from children in delinquency cases. And I urge you not to make a distinction between these kids in Chin's delinquency and abuse and neglect cases. They're all the same kids. They all come from poverty backgrounds. All, maybe an exaggeration, the vast majority come from poverty backgrounds, experiencing childhood trauma. They all are sent to these institutions for the same reasons. Ostensibly to have treatment. So I do not see, I think it's unfortunate that the system distinguishes between abuse and neglect, delinquency in Chin's kids. Maybe someday we will change that also, but there is not a distinction amongst them for the purposes of congregate care. And I would suggest also there's an equal protection right these kids have to counsel in 169C cases because their peers in 169B and D cases already have that right. That is written into the statute.
Thank you. Do we see any questions? Representative Scher?
Do we need to extend this exception to 2027? It sounds like, tell me if there is still a shortage of attorneys in these cases so that we need to continue this exception for a little over a year.
So the Children's Law Center is part of a policy advocacy group of the Youth Policy Advocacy Coalition. You
Okay.
heard from Karen Rosenberg at DRC, who's also a member of that group. It includes New Hampshire Legal Assistance. It includes New Futures. It includes Waypoint. And we came to a compromise with the division over that extension to 2027. So we support SB 515 as amended by the Senate. We do not support an amendment and strongly oppose an amendment that would make that carve out permanent. So
So my question is the opposite. What about an amendment that gets rid of the exception now? Is that administratively and feasible in that there already are enough lawyers out there? We don't need this carve out anymore?
I mean, we've agreed to support. So I'm not, here's what I will say. I wanted to make this point, so Representative Sure, you reminded me. The division said there were about 150 kids and all have been assigned counsel. Just bear in mind, one lawyer can take multiple cases, right? It's not 150 kids, 150 lawyers. I mean, you probably take at least 5 to 10. So I don't agree that there is a shortage of lawyers. The courts have done really well. I've talked to clerks who've been very pleased about how efficiently this has rolled out. I've talked to DCYF lawyers. I've talked to CASAs. Things are going well.
Thank you. Representative Georges.
Thank you, Madam Chair. Thank you for taking my question. I just want to know because if there is a delay with the DCYF because there is no representative because those kids need to hear a voice for the legal assistant. You guys can provide.
We can't take every case. We're a growing nonprofit. I'm not so, but we do our best to take every case we have the bandwidth for.
Thank you.
Thank you.
Seeing no further questions, thank you very much.
Thank
I
you so much.
appreciate your time.
May I hand out?
Yes, please.
Thank you so much.
The next person I'll call on will be Jessica King. Good morning.
Good morning, Madam Chair, members of the committee. Thank you. My name is Jessica King. I'm here on behalf of the New Hampshire Judicial Branch. I actually wasn't planning on testifying today, but there have been some questions that I've heard throughout the testimony before me that I'd like to maybe help out with. Right now, all children in residential treatment in RTPs have been afforded attorneys. So the program has been working well. What the amendment in the Senate did was give us a little time to evaluate how this is going. It was a phased-in approach. As of January 1st, I think the last phase was of January 1st of this year. So we want the time to understand and make sure that this program, that the attorneys, that the bank of attorneys that are taking these cases is sustainable and doing the work that we anticipate going on. So that is the reason why the parties came together, made this compromise to ensure that both the child's interest in having an attorney is protected, but also that these cases, these important cases, can go forward and permanency can be decided.
Thank you. Representative Scher.
Since this carve out has existed, how frequently, if ever, has it been used?
I don't know the answer to that case. I'm sorry, or that question, Representative.
Is there a way to get that information?
Potentially, these cases are difficult to gather information from because they're so confidential. But I can see if I can get that answer for you.
That would be very helpful.
Yep.
Thank you very much. The final card I have is from Marty Sink. Good morning and thank you for coming.
Thank you. Thank you, Chairman and members of the committee. My name is Marty or Marcia Sink. I'm the CEO of CASA of New Hampshire. As you know, a volunteer guardian ad litem program. We've been around for 38 years, serving abused and neglected children who enter the court system as a result of that child abuse or neglect. We were, as an organization, in full support of Senate Bill 515 as introduced by Senator Long. And we do oppose the current bill with that amendment that does not allow for some of these cases to move forward. Should we be in a position where the court cannot find an attorney? So we've been into this new process for the past 3 months, just since January 1st, where attorneys have been appointed for our kiddos in residential. They've all received an attorneys, as you've heard. The bill with the current bill, in our opinion, if we go forward with at 1 year out, that we do not allow some of these children's cases to move forward without counsel, we're potentially furthering the trauma and that they are affected by being in residential on top of the trauma that they've already experienced as a result of the abuse or neglect. It's important to know that CASA Guardians ad litem and other guardians ad litem, yes, we share with the court what we feel is in the best interest of the child. And that's after spending extensive time with these kids, visits every month, talking to teachers and physicians and other significant family members. We're gathering this information, presenting it to the court as it stands in the best interest of the child. We also encourage our children and youth to attend their court hearings. And this was years ago that the Court Improvement Project, CIP, developed protocols around helping children feel comfortable with attending court during certain proceedings, not all proceedings, but during certain proceedings. And the court is hearing from so many of these kiddos what they want. And sometimes it's not in their best interest, but it's what they want. And that's what the court is hearing. The CASA Guardian ad litem and other guardians ad litem are also required under New Hampshire court rules to include in their reports what the child's expressed wishes are. That's a requirement. So we are not only giving the court what the guardian ad litem feels is in their best interest, but we are also, there's a section in our court reports that talks about what this child wants. We may have a 14-year-old who's been in foster care, wants to go home. She's been sexually abused by mom's boyfriends. Mom has not done a good job of protecting her for a variety of reasons. But this child wants to go home. We have to inform the court that the child wants to go home, but the guardian ad litem or the CASA feels it's not in their best interest. And up until the court also had the opportunity to appoint an attorney if they felt there was a conflict expressed or shared by the guardian ad litem with what was in their best interest and their expressed wishes or expressed interest. So I just wanted this committee to know that we are being so cognizant of what these children want, what their needs are. And we've been doing this work for a long, long time. Last year, we were appointed to over 900 cases of child abuse and neglect, and we served nearly 1,500 children with CASA GALs. And they're doing an extraordinary job. Our training is incredibly extensive, not only our core initial training, but all of the ongoing training that we provide to our CASA guardians ad litem all the time, year round, on various topics that would affect these cases that they're working on. We also have a core of 3 attorneys on our staff at CASA that step in when there are legally challenging cases, that they can work with the CASA guardian ad litem and other staff to ensure that these children are protected under the law and that they are allowed to give voice to their situation. So that having those attorneys on our staff has been really key to ensuring that during very complicated, more intense, legally challenging cases that we have access, our advocates all have access to counsel within the CASA organization.
Thank you.
Sure.
Questions? Representative Gregg.
Thank you, Madam Chair, and thank you for being here. It's nice to see you again. So I have a question. We are one of, before this came about 2 years ago, we were one of only like maybe a half a dozen states that did not have a right to counsel for children. In your testimony, it kind of comes across, are you saying that that's not really necessary because we have CASA, that we do not need a right to counsel?
No, I think on certain cases, absolutely, children should have and youth should have a right to counsel. Whether it's necessary in every case, I personally don't know that a 3-year-old or needs to have counsel.
Okay, can I do a follow-up?
Sure.
So is it not? It is great. CASA is a great service. Our guardian ad litem is a great service. Is it not able to work in concert with an appointed attorney or an attorney for a child? That there's not cooperation?
No, we have, absolutely. There are some fabulous attorneys that are being appointed to these cases that we've worked really well with. So there can be a very collaborative approach to these cases. And ultimately, it's the kiddos that win. So, I mean, it's all about children. It's not about our own issues necessarily, but it is about how can we best serve these children who have been victims of child abuse and neglect. I don't know if that helps,
Thank you.
but we do work with attorneys as well.
Representative Scher? No? I show no other hands. Oh, Representative Georges?
Thank you. I think so from my best understanding to hear you, if the children, they are delayed to stay in CASA or GCYF, it's not about the attorney, but it's for the best interest of
We don't think that the proceedings for these children should be delayed because in these rare exceptions, we cannot find an attorney. We might be up in Berlin court, and we have cases all over the state in every court, and up in Berlin or Haverhill, where attorneys are not available at times or not as readily available as in Manchester or Nashua or something. We would hate to see these cases delayed temporarily till an attorney could be found, but let them go forward with the collaborative approach that we have with DCYF, with CASA, with other stakeholders on these cases. And because we are ensuring that the court knows what these children want by virtue of our reports to the court on a regular basis. So we would hate to see these children lingering longer in care as a result of not having counsel.
Thank you so much. Follow up?
Thank you. I just want, because if you say a 14 years old want to go back home, but because the father maybe was, there is no way to help that child because she want to stay with the mother.
Sorry.
I'm sorry, because it's a trauma too. We are putting it to that child because doesn't want to stay over there, want to stay with the mother.
Right. Thank you for your question. I would suggest that with services that we can get to that parent and make that home as safe as possible for that child to be returned, we would absolutely be advocating for that. So we work really hard. Our system works really hard at getting the services to families so that children can be safely reunified with their parents if they have been placed in residential or foster care.
Thank you. Thank you very much for your testimony and answering all the questions. I appreciate you.
Thank you.
Thank you.
Appreciate it.
With that, I'll close the hearing on Senate Bill 515. Exactly. I'm going to open the hearing on Senate Bill 608. And I'm going to recognize Senator Waters.
Thank you, Madam Chair. I'm Senator David Waters, District 4. Good to see you, Madam Chair, members of the committee. I'm here to introduce Senate Bill 608 relative to family caregiver support and certain programs and child care support for kinship caregivers. I do want to thank New Futures and particularly HHS for all the good work that was done dealing with the technical aspects of the waivers and the financing that might be affected by it. The bill basically does three things. It directs the Commissioner of the Department of Health and Services to seek some waivers from CMS so that caregiver support can be included in the programs for acquired brain disorder and choices for independence and home and community based services. Then it outlines those services, and then secondly, you'll see on section 2 that it makes a slight change there to make sure that there is evidence-based trauma-informed care at no cost to the provider, so that they can get the kind of training from folks they have to have. And then the third part of the bill is that it modifies the work requirement for child care scholarship programs to include participation for any individual who has reached retirement age as defined by the Social Security Administration. And then there's some financial things I'll get to towards the end of the bill. So just to talk briefly about these. It basically will extend the family caregiver support services to qualified individuals and take action on child care support for kinship caregivers. I think you all in this committee know how incredibly important kin caregiving is. 1 in 4 adults in the United States and 170,000, that means in New Hampshire, I've been one of those, are involved. It's, people who love their family members and want to be able to care for them if they have some support to do that, and obviously a great savings to the state and others if this kinship can be provided. And I will note that on that first section there, we do have broad discretion in our waiver program to address the needs of the waiver's target population, and these programs, the kinship caregiver would be an important thing. 26 other states are doing this now, received that waiver, so there's confidence that we will be able to get that. And just as a reminder, the federal government does provide half of that funding for that, provides funding for that program. Then the third part of the bill that has to do with the work requirement, here too, we have the capacity to seek this waiver, and you'll see on page 3, lines 15, the other categories of people we offer the waiver for. And I think we all know that we're facing a real increase of need for grandparents to be providing kinship services for their children, and therefore the need for child care should be extended to those families where that kinship support is being offered. And I will say, as someone who's been retired for 8 years now, that if I had to go back to work, I'd be in some real trouble. And so I think that, we had testimony in the Senate of people who might be in their late 70s, into their 80s, who are now taking care of grandchildren. And, so I think this is a very reasonable thing. And also, we did hear that there may not be a whole lot of children who now will be getting the daycare services. This is not going to be a huge number of children, so I think it will be quite manageable. Lastly, I want to talk particularly about sections 5 and 6. We spent a lot of time in the policy committee, trying to make sure there was no fiscal impact on this budget. So we did two things. We said, here's a contingency that says that we're not going to start paying for things, of course, until we get that waiver. That waiver is going to take a little bit, it's going to take some time, so it'll get us into the next budget. But just in case it comes before the next budget, you'll see on 6, we added this in finance to say that this will go to fiscal, just to make sure that because we wanted to obviate the fiscal note. Since the time we passed this, we've heard from Health and Human Services, John, to say that they may need, there's an issue around the financial note related to the systems changes that might need to be made because of changing the program, the computer system have to change. There is a cost to that. He has an amendment. I think it too can kick it out into the next budget. If we had known about this issue in the Senate, I think the amendment is just what we would have done. Thank you, Madam Chair.
Thank you very much. Any questions? Representative Raymond?
Thank you. So I have a technical question, I guess. On
Yes.
page 2, lines 11 and 12, it says anyone who's reached the retirement age as defined by Social Security, which I think is great. But having parents in that age bracket, I'm aware that it's 67, but there are cases where it's 62. Does this bill, what does it mean for this bill? Is it only the 67, or is it however Social Security defines it?
Well, thank you for the question. And I think that the language here gets right at that, because people are going to be in different categories about when you were born, when they went from 65 to 67, whether you at 62 for some. So this basically says that whatever the Social Security rules are,
Okay,
that's what we'll go by.
great. Thank you.
Thank you.
Thank
Thank you so
you.
much for your time.
I have to go back to
Um,
the committee if there are more questions
yeah.
for me, Madam Chair.
2 minutes. You're going to get 2 minutes. I'm sorry, Senator Altshuler. You asked for 2 minutes, you'll have 2 minutes.
Great.
Thank you.
Oh, it's already on. Good afternoon. Thank you, Madam Chair, members of the House Children and Family Law Committee. Nice to be back with you. I am Senator Deborah Altshuler, and I represent District 24. I am here today because the issues of kinship caregivers affect my district intensely, and also my friends, who I want to tell you about today. Patricia Vincent Piet and her husband, Jim. They live in Concord, and I submit this testimony today on their behalf. In 2020, at the beginning of the pandemic, Patricia's husband, Jim, lost all of his paid caregivers. Jim has cerebral palsy and needs help with the most basic self-care, like eating, using the bathroom, and staying healthy. Patricia had to quit her job to provide his care around the clock. Fortunately, the state was able to pay for some of that work so that she didn't lose the entirety of her income. Currently, Jim has another caregiver, but Patricia still spends 40 to 45 hours a week supporting him. Patricia also has cerebral palsy herself and has been struggling with long COVID since February of 2024. If she lost the income from Jim's care, then she would have to get yet another job. And this would mean leaving Jim alone for long stretches of time and putting him in danger. It would also mean endangering her own health by forcing her to essentially work 2 full-time jobs. And she told me, Deborah, I don't think I could do it. Jim and others like him deserve good care, and those providing that care, like his wife Patricia, deserve support and reasonable compensation, even if the caregiver is a relative. Family caregivers save our state millions of dollars every year by keeping loved ones out of expensive institutions like nursing homes. Investing in them is an investment in our state and the well-being of all of New Hampshire residents. On behalf of my friends, Patricia Vincent Piet, and Jim, I thank you for this time and encourage the committee to recommend Senate Bill 608 to pass. And I would just like to note for the committee that when Senate Bill 608 went through HHS and had a committee amendment, it was recommended 5-0, and then subsequently passed on the floor in a voice vote. It was referred to finance, tweaked again, and came out of finance with a 6-0 ought to pass recommendation, and again passed on a voice vote on the floor. So I hope you will also support this bill. Thank you. Did I
Thank you
hit
very
my time?
much. Yes, you did.
All right.
Thank you for coming.
Thank you.
Next, I'm going to call Amanda Carter. Considering the hour, you'll be given 2 minutes. If you have written testimony, please pass it in rather than read it. Thank you.
Thank you, guys. I know you said you don't want me to read it. I did pass it around. My main thing is I just want to appreciate that the bill gives prevention and support a priority. It helps families early before stress turns into a crisis, and builds on what tools these families already have. My name is Amanda Carter. I am a kinship navigator at the River Center, Peterborough, the River Center Family and Community Resource Center in Peterborough. I see cases every day. I have a client right now who is a single grandmother taking care of a 6-year-old, and this 6-year-old has disabilities as well. She works as a home cleaner. I had to help her find childcare so that she could clean more houses, so that she could pay for the childcare, just so that she could keep their home up and running. And so I just want to really express how important the taking away of the child care scholarship cost share is going to be for these families. Thank you.
Next, I'll call on Kathy Dickey. If you have written testimony, please pass it in. And after you introduce yourself, you'll have 2 minutes.
Thank you. Hi, as you know, I'm Kathy Dickey. My husband John is here with me. We live in Bow, and we're here speaking in support of SB 608. John and I are raising 4 grandchildren. They're 9, 5, 6, and 3. The 9-year-old came to live with us when he was just 10 months old, and he's a joy. John and I were both still working at that time. And when we planned our retirement, we planned it with Emmett, and we planned our finances accordingly. We both retired in 2018. I was a registered nurse for over 40 years, and John was in insurance. In February of 2023, 5 years into our retirement, DCYF placed our 3 youngest grandchildren with us. At that time, they were 3, 2, and 5 months. They were all in diapers. The baby was still being bottle fed and had to get up at night. To say we were overwhelmed is an understatement. We have the love for them, but we're really worried as a retired couple on a fixed income. How could we give them everything they needed? Diapers, formula, food, clothing, and daycare. Fortunately, DCYF right now is the legal guardian of the children, and they are able to cover daycare, which was life-changing for us. The children have learned social skills, how to play with other children. They got occupational therapy. They got speech therapy. They've improved their speaking skills and self-confidence in themselves. It's been a joy to see how they've blossomed over the last 3 years. Raising 4 grandchildren takes a village. Daycare is a huge part of our village. The parents have lost their parental rights, so John and I are moving forward to become their legal guardians. Once that happens, DCYF won't be able to pay for childcare. So we started looking into any financial assistance that we could get, and we found out that we're not eligible because we don't work. John's 74 and I'm 71. And for them to stay in daycare, we'd both have to go back to work, which We could, but it's not really feasible at this age. There's a lot going on with the four of them. This bill would allow our grandchildren to stay in these young educational programs and they could continue to thrive. We're doing the very best we can, parenting the second time around, to help give our grandchildren the best opportunities to continue to develop their social and emotional skills and build a foundation so they can be healthy and happy and successful adults. This bill would help us do that. Thank you so much. And I urge you to support this bill to help me and all of our families like us. We all thank you, John and myself and Emmett. Does anyone have any questions?
Seeing none. Thank you.
Yes.
Sorry.
What do you use on your face? Because your skin is beautiful and you do not look your age.
I was thinking the same thing.
So was I. I'm like, there's no way. Oh,
you.
dear. Thank you.
Thank you very much.
Yes. Next, I'm going to call Attorney Brian Clark, Wendy Altman, and Jonathan Brayman all together. You'll have 2 minutes. I hope you can each take a little bit of time.
Thank you. I'm Brian Clark. I'm General Counsel for the Bureau of Adult and Aging Services and the Bureau of Child Development and Head Start Collaboration.
Hi, I'm Wendy Altman. I am the Bureau Chief of the Bureau of Adult and Aging Services.
And Jonathan Freeman, Administrator of Operations for the Bureau of Child Development.
And so, in addition to what has already been said about what the bill does, I just wanted to point out that there would be $310,000 of impact on system changes that are needed in this biennium. So we're working on an amendment to get that addressed. Okay, thank you.
We have that amendment.
And I'm available for any questions.
You're amazing. Thank you.
Thank you. Did you want to say?
Okay. Yeah, what about your skincare? I love the beard.
Do I still have, do you give us all 2 minutes?
No. We'll give you a minute. Thank you.
I'll bring this closer. I'm really here to more speak to part one of the bill. We call it part one and part two. Part one really is looking at incorporating supports for family caregivers in our Choices for Independence Medicaid waiver, which is for individuals who meet nursing facility level of care. But what we find most often is there's many family caregivers or kinship family caregivers providing the bulk of the care that isn't covered under the Choices for Independence waiver program. So in aligning with many other states who have incorporated caregiver supports into their waiver, this bill will allow us to do that, but really within a phased-in approach and based on cost neutrality. So it would be based on the cost of our total waiver and the funding that we have in our accounting unit within the Bureau to fund Choices for Independence waiver. So I wanted to just speak to that. We do feel like there's definitely a need in terms of the identified family caregivers who have individuals receiving services in CFI, and wanted to be available for any questions that the committee has.
Thank you. Did you want to speak, sir? I can give you a minute.
My skincare routine is to grow a beard, so it hides my face. I'm here for part two if you had questions about the childcare scholarship portion. But other than recognizing the value of the change, I don't have anything to add.
Thank you. Seeing no questions, thank you very much. Next, I'll call Roger DeRochers. You have 2 minutes, sir.
Thank you, Matt. I'm just going to make this brief. First of all, my name is Roger DeRozier, and I'm here from Concord, New Hampshire. I'm here to testify on just not just my behalf, but also for AARP New Hampshire. We are here today in strong support of Senate Bill 608. This bill is essential for strengthening family caregiver support and providing child care assistance for kinship caregivers in New Hampshire. I'll just skip the rest of the testimony and give my brief personal experience as a caregiver. My wife and I were caregivers for my dad for approximately 18 years, beginning in 2001. At that time, caregivers did not have resources for meeting the needs of a family member. We were challenged with working full-time and trying to meet my dad's needs for multiple medical appointments, management of heart medications, in-home medical testing, transportation, and later his Alzheimer's disease. Our own needs for caregiver support services were not available or very expensive. In addition, resources for managing his medical care were inadequate or not available. For these reasons and others in my testimony, I urge the committee to support this bill, and thank you for the time and consideration.
Thank you very much, sir. I appreciate you, and I'm sure your dad did. God bless you.
Thank you.
Next, I'll call Attorney John Williams.
Madam Chair, members of the Children and Family Law Committee, for the record, my name is John Williams. I'm the Director of Legislative Affairs. Thank you for allowing me to come before you today on this bill. And I'm here just for limited purposes because we had already testified as an agency on the need for systems-related costs associated with it. This is a fine example that given the amount of time and energy for the committee to actually work on responding to the department's concerns is greatly appreciated to address those financial concerns, as well as many of the advocates who are the sponsors on this bill that are here today that work very collaboratively. I just have to call out Representative Rice on your committee. She is the masterful person in collaboration. And also both the Senator Waters and his willingness to work with the department, as well as Representative Mary Jane Wallner. And I have to also comment on Attorney Jones, who also contributed to our conversation. I feel like this is an Academy Award speech, and with that, that concludes my testimony.
Thank you very much.
Thank you.
Next, I'll call Susan Labrie. Thank you for coming today. You have 2 minutes.
Thank you. Very welcome.
Thank you.
My name is Susan Labrie, and thank you for the opportunity to speak to you today in support of Bill 608. On March 4th, 2022, our 5-month-old great-nephew came to live with us. His name is TJ. DCYF strongly urged us to gain guardianship, which we did. At that point, they vanished. Didn't see him anymore. Our pediatrician, we had no help whatsoever. Our pediatrician connected us with Waypoint, who helped us enormously. They got us childcare for TJ. Okay, 10 months after TJ started childcare, we got a letter from the state telling us that they would no longer pay as of October 31st. I called up. They said, we only pay for 1 year. However, if you can go back to work full-time, go to school, volunteer full-time, we'll pay for you. I'm 78 years old. My husband's 79 in poor health. Hello. So, okay, I got a doctor's note from my husband. You're only allowed 1 sick person per family. So I got a doctor's note for him saying that he couldn't work. And I enrolled in college. Sign language. That was another disaster. I don't know how to zip a file and send it. Okay, nor do I know how to attach a file to this file and send it to this. Don't. I failed. However, DC state said, okay, because you could only go part-time, we're going to pay $113 of the $325 a week. So they pay that, I pay the other $212. Problems kept coming. I had to secure financial aid. That's a disaster. I had to prove that my husband was out of the service. Even though I have a certificate, okay, I had to obtain my high school certificates from 60 years ago. Thank you. Okay, so I had to contact 3 high schools and ask them for my freshman, June, all that, right? Okay, we still don't have all of them. Okay, TJ is thriving. He's doing very, very good. I can't take him out of daycare. So consequently, we use our 401k. We had to dip into that to pay for it. It's, I don't know what to say other than, we'll continue to pay for him. People tell us, you're so lucky. And we tell them, no, we're the lucky ones. If you could meet this child, his curiosity, his hugs, his laughter, his I love you, Auntie, so much. I love you, Uncle, so much. It's just beyond measure. When we retired, we had a bucket list, really nice bucket list. We were traveling. Gone. Gone. Our bucket list now says, TJ, that's it. That's all that's on there. Please, please, please help families like me and pass SB 602. Did I make the 2 minutes?
A little more, but that's okay. Great job.
Thank you.
Thank you very much for coming and sharing with us.
You're welcome.
Thank you. The next person is Elena.
I will.
2 minutes.
I will try to shorten this, and I did pass on the written testimony as well. My name is Elena Slige, and I am here in support of SB 608, and it's more important that I am here in support of and advocating for the families' stories that you have heard previously. I am a CFI case manager with Crotchet Mountain Community Care, and I bring 15 years of experience working with ABD, DD, and CFI waivers, supporting families in the background for many years on a wide variety of spectrum. Writing and speaking in strong support of SB. This bill will directly align with a core mission of our home and community-based care services, keeping individuals safely in their homes and preventing unnecessary placements in skilled nursing facilities. I will shorten this to skip to a couple of chapters. This bill offers a practical and cost-effective solution by providing access to the caregiver training, peer support, and education, and equips family with the tools they need to succeed. It transforms caregiving from overwhelming burden to manageable, sustainable role. More importantly is even modest improvements to our caregiver support can lead to meaningful system-wide benefits, reducing caregiver burnout, and increasing successful home placements will decrease reliance on a costly institutional care, resulting in the long-term care savings for the state. From my professional experience, caregivers who engage in training and support services are significantly more successful. They are better prepared, more confident, and more resilient to their roles. During transitions from rehabilitation services, family must navigate safety planning, home modifications, and new to them medical and behavioral needs. I will make this short. I wish at most of the discharge plannings that I participated, sitting at the long tables, listening to stories in the background, I can offer them a resource they can turn to, supports. The standard procedure was for me to say, watching people cry and their overwhelming faces, is find a support group, find resources. What they are, good luck. I don't know what they are. Google in your area. But I would like them to offer them a structured support to succeed. Not all families will utilize these services, but I hope many people will. And those who will, impact the impact could be life-changing.
Thank you.
Thank you.
Thank you so much for coming today.
Thank you.
Next, I'll call Ashley Sinan.
Good
Thank
afternoon.
you. 2 minutes.
My name is Ashley Sinan, and I am the director of the Seacoast Dementia Hub. The hub is grant funded specific to caregivers caring for their loved ones with dementia or Alzheimer's. Since launch in September, the Dementia Hub is actively serving 49 primary caregivers, and there has been an overwhelming, in just my data collecting, an overwhelming need for emotional supports and resources. A lot of these caregivers feel so isolated. It is so frustrating for them to navigate where to turn, what to expect. And what I'm seeing is with the complex emotions that come with being a caregiver, that lack of emotional support, there is such a need. So I just very passionately am in support of State Bill 608. Thank you.
Thank you and have a nice day. Next, I'll call Lily Wellington. Two minutes. Thank you very much.
Good afternoon, Madam Chair and members of the committee. For the record, my name is Lily Wellington, and I am the Executive Director for the State's Commission on Aging. So the Commission is in support of SB 608. I'm passing out some written testimony. And one of the facts that I wanted to highlight for you is why the context for this conversation matters now. So when you look at the demographics of an aging population, most of you might be familiar with the fact that New Hampshire has the second oldest median population in the country. We are second only to Maine, and we are tied with Vermont. So one of the facts that matter here is the number and ratio of caregivers to potential individuals who are over the age of 80. So for instance, in the year 2010, there were 7 potential caregivers for every individual who was over the age of 80. That number is expected to decline to 4 by 2030. So that means that there's a distinct drop in the ratio of available caregivers for every individual who is 80 plus. So there is a logical value in preserving and supporting our existing pool of caregivers. So this bill is a really logical way of providing some honest support for this population. Thank you.
You're awesome. Thank you very much.
Thank you.
Next, I'll call Judith Jones and Trina Engelfinger. Collectively, you'll have 2 minutes. So if you each want to take one.
We'll take 1 minute.
Okay.
Good morning and to good afternoon to the committee. My name is Judith Jones, and I am Policy Director for Healthy Aging at New Futures and also represent the New Hampshire Alliance for Healthy Aging. And I am Trina Engelfinger, Policy Director at New Futures for Early Care and Education. And we want to thank you for the opportunity to speak in support of this caregivers bill. Caregivers, as others have said today, save the state millions of dollars every year, but you have also heard that this work takes a toll on their physical, mental, and financial well-being, and they need our support. And for kinship caregivers, one crucial support is childcare. The Child Care Scholarship Program is the program that most of those families rely on for that support, but that program has out-of-pocket cost share payments, and retired caregivers, as you have heard, have to go back to work or enroll in school, no matter their age, to qualify for the scholarship. In fact, the Child Care Scholarship is the only subsidy program in New Hampshire that doesn't have an age cap on its work requirements. So we think that that's not fair to the families that do so much for our state, and SB 608 would remove these barriers by simply removing that cost share, capping that work requirement, and keeping kinship families in childcare. And I'll pass it to Judith.
30 seconds.
So very briefly, this is a committee that understands the power and the potential of New Hampshire families. So we're very grateful that we had a chance to come before this committee. And these caregivers have been called the invisible backbone of the state. And we would like to make them the visible backbone where they support economic, healthcare, and financial. And the work that they do annually has been valued at $2.8 billion. So to keep these folks in the game, supported, we ask you to vote that the bill should pass. And thank you for your attention today.
Thank you so much. Thank you. Nice to see you again. Have a nice day.
Thank you.
The final card I have is Chase Eagleson. 2 minutes.
I realize I'm probably holding you back from your lunch, so I'll be very
Okay.
brief.
No, it's many of us have another appointment.
Oh.
That's all. It's not lunch. You're more important than that.
Well, thank you. My name is Chase Eagleson. I serve as the Policy and Planning Coordinator for the New Hampshire Council of Developmental Disabilities. We're a federally funded state agency mandated by the Developmental Disability Bill of Rights Act. We come in support of this bill. I passed around some testimony from our executive director. This is a sustainability issue as much as anything. There is as we know, workforce crisis when it comes to direct care workers, and people with disabilities need a lot of that care. And family members take up a lot of the work difference that's left over, and sometimes completely take over all the work. Passing this bill would help ensure that people with disabilities receive all the care they need, and they're able to live in the community, which is the most economical option. I'll leave it there.
Thank you so much. Thank you for coming today. We appreciate it. We appreciate all of you helping us today. And I hope you have a fabulous day. And with that, at this time, I will close the hearing on Senate Bill 608. And we have to book it.
Yeah. Okay.